Ms. Wilson and I did of this particular witness, and at that time, there was no report for me to study. There was no documents that we did not have in discovery already, and very few of the documents in discovery had been reviewed by this witness. So I have no idea what else has been done since then.
Well,
And
just clue me in, because I have no clue of what you people are talking about. Obviously, it's a proposed expert in what area?
Acute stress reaction, Your Honor.
and usually
Are you
when-
anticipating we're gonna have a Daubert hearing?
I don't know, Judge, because I haven't seen a report. I don't know what the extent of his expertise is in that area. This is a very nice man who has expertise in dealing with juvenile
Okay.
delinquents.
Well,
so
then the man is here.
Yes, Your Honor.
And have you shown the state a report that he's conducted?
He hasn't done a report, Your Honor. They had asked him if he did a report. He hasn't done. He has his work product in his own notes, but he's never provided me a report, and I've asked him. He's never done a report.
Then I think I'm entitled to
Does he have
the
some
notes.
opinion that he thinks he might want to try and render?
In the short of it, Judge, to proffer it, this is a man that actually has knowledge and training in terms of fight or flight responses, even with first responders. He actually even counsels law enforcement in situations like this when they're taken off the road after shootings, in terms of how people react after fight or flight responses or shootings. So his opinion's going to be, and the long and short of it is, how people react or tend to react after situations like this, Judge.
Okay.
The state will be able to talk to him. He has reviewed evidence, he has reviewed notes, he has talked to people. But the state never asked to redepose him, but I did tell them I would make him available as he is.
Okay.
I thought I did ask to finish the deposition. Judge, here's the problem. I can't even ask for a FRI hearing, or I guess we're now on Daubert, whatever standard we're using these days. I can't even ask for that because I have no idea what this man's gonna say. He had not reviewed more than a couple of items pertaining to this case. So
Well,
there's,
what do you want me to do,
well,
if anything, right now?
we will object to this witness taking a stand. As far as I can tell right now, only based on the limited knowledge he had at the time I took his deposition. I don't think he meets any standard of admissibility of evidence other than a personal opinion, which would not be admissible.
All right, well then what we'll do is you all can either interview him just face to face, or you can depose him this evening to find out where you want to be. We'll do that after, or you all can go do that after we've talked more about jury instructions. And then we will have to meet here at 8 o'clock in the morning to decide what you think you all want to do and have a hearing about it if we need to. My intention is to start at 9 o'clock. And my understanding is, correct me if I'm wrong, Mr. Strolla, that would be potentially maybe your last witness. You may have two, but this would be one of them.
You are correct.
So maximum, you've got two witnesses. Minimum, you got one, and this would be the one.
Yes, sir.
I would like to review the notes before speaking with or deposing the doctor.
That's fine. So you need to provide, or he needs to provide whatever he's got so the state can review it, I guess, so they can be in a position to ask whatever questions they think they need to. Okay?
That's fine. I don't think work product can be turned over, Judge. They can
Well,
ask them.
and I don't know what form these things are in.
And that's why I said if they're notes and work product, that can't be turned over. They can ask what it is, but I don't think you can turn it over other than a written report with an opinion.
You're probably right. If it's work product, it's work product. It can't be turned over. So
Sorry, Judge.
maybe, you know, I don't know how y'all are going to handle it. Should we move on to talking about jury instructions?
If I have a moment to grab them, Judge.
Sure. Before we get to that, Mr. Dunn, I've asked you time and time again, you satisfied with everything that's gone on so far?
Yes, sir.
I already did,
Oh, I apologize.
not a problem. Satisfied with the witnesses that were called on your behalf today?
Yes, sir.
All right. Any folks that you would have wanted called today that weren't?
No, sir.
Okay. And you satisfied with Mr. Strolla's representation of you thus far, as we've said continually? Okay. Jury instructions. We kind of went through a lot of them the other day. Mr. Strolla, have you decided on the lesser includeds to attempted first-degree murder? Our issue was, is it attempted voluntary manslaughter or attempted manslaughter by act? Based on the, if I can find it here, that most recent opinion that popped up. Which I'm now not putting my fingers on. Aha. Yeah, this was the opinion from the Supreme Court that came out just the other day, February the 6th. And when we spoke the other day, I said, you need to read it and try and figure it out. Did you get to figure that out?
I have not, unfortunately not. I did review it, but it all came to support. I didn't thoroughly go over it just because of everything else going on. I'm still probably as confused as I was that day of them saying, here's the new instruction, but then the new instruction doesn't hold true, but the old instructions are returned.
All right, well, let me just tell you, because we're getting into the home stretch. This case is the testimony of it will conclude tomorrow. I'm anticipating that depending on what happens with this expert and how long we need to debate those issues, if there are any, initially I was thinking that we would probably be finished by noon. That might be a little optimistic. If that were to happen, my intention would be to let the jurors have lunch and begin closing arguments tomorrow afternoon. And my intention would be, assuming we're on that time frame, to finish the closing arguments at whatever hour tomorrow, break, because I expect that will be the end of the day, bring them back the following day for the jury instructions and let them begin to deliberate their verdict. Now, the only thing that can throw a wrench into that is this expert and us having to take a longer period of time to resolve that. That being said, we have to have a decision on this attempted manslaughter by act or attempted voluntary manslaughter. And I believe, Mr. Stroller, what I said was I was going to leave that decision up to you. You can call it, you tell me what you want me to call it. Looks to me like, and I've got to read this again myself because it is confusing. It looks like we can call it either one. So I'm going to give you the choice. But we also have to have the language solved. So that's one issue.
And Judge, my only slight concern with that, if I may, is that even for the past few years, when both the state and the defense agreed to the standard manslaughter instruction, we still had cases reversed when even the law was all we had to give. So I would welcome any suggestion from the court. I've had two of our people look at it who we consider to be experts in, case law. I will welcome any other suggestions because I again, just don't know how to interpret that opinion.
My intention is the best I can do.
Yes, sir.
Is to let Mr. Stroller be the one to decide it. That way it was the defense's decision.
Yes, sir.
They could not then, well, should not be able to then use that as a reason to challenge a conviction if that's what were to happen. I would intend to inquire of Mr. Dunn that he was satisfied that that's the route we took, and that's as good as we can do. If for some reason the appellate court said, we don't care if you all agreed, we don't care if Mr. Strolla was happy with it, we don't care if Mr. Dunn was happy with it, it's a bad instruction after the fact, we're just stuck with a bad instruction after the fact.
Yes, sir.
Hopefully that won't happen, but it's always a possibility. So we've got to solve that, ladies and gentlemen. That's number one. Number two, that dealt with the instruction on page 19, which is just enumerating what the lesser includeds are. We got to decide what we're going to call it.
Yes, sir.
Then we've got to, on the same issue, we've got page 23, where we've got to again decide what we're going to call it.
23 and 24, sir, were the original instructions prior to the Supreme Court opinion that we had all already agreed on.
Right,
There, for the
But-
yes, sir, in the yellow highlight.
right. And there's one that says attempted voluntary manslaughter, and there's one that says attempted manslaughter by act. So we got to
Right.
pick one.
We have to pick one set of those because, yes, sir.
Then on page 27, the instruction for shooting or throwing deadly missiles. Our question was, were there any lesser includeds?
I didn't see any schedule one.
Did we do that?
I think we asked it, left it as it is. The state-
Right, I think we all thought there weren't, but I said we need to find out and make double sure whether there are.
We
Yeah,
did
please,
check-
one at a time. Go ahead.
We did check, we didn't find it.
So, Mr. Dunn, or excuse me, Mr. Strolla, your opinion is there are no lesser includeds to count 5.
Not in the first read, we find it, no, sir.
Mr. Dunn, are you satisfied that we would just read that instruction? And in essence, then, that's one of those, I call it all or nothing.
Yes, sir.
Either they find you guilty of it, or they find you not guilty of it. They don't go through this litany of lesser things.
I understand, sir.
All right, and you're satisfied with that,
Yes, sir.
okay? So that solves that issue. The next issue was weighing the evidence. We knew we were going to have 6, 8, and 9. We do not have 10, because that was a reputation for dishonesty or truthfulness, so we don't have that. And then I don't see that we have 7, which was any pressure or threat used against a witness. But Mr. Strolla, do you see any of that? Are you requesting either of those?
Not for 7 or 10, no, sir.
Okay. State, 7 or 10?
Not at this time, Your Honor. And do you want to tell me how exactly you want 9 to read? So, because it has options, and I'll just type it in the way
I
you
want it to read, has the witness been convicted? Well, we only have one, and that was the young fellow that was on probation.
He was not convicted, nor was
Oh.
the evidence that he was convicted.
No, Mr. Atkins, not
Mr.
Mr.
Atkins was used.
So has a witness been convicted of a felony?
Question mark.
Period.
Yes, sir.
Well, yes,
Oh.
question mark. There's no need to put a misdemeanor involving dishonesty or false statement because we don't have any evidence of that.
Yes, sir, I took it out.
You agreeable with that, Mr. Strolla?
Yes, sir, Your Honor.
Mr. Dunn, you agreeable with that?
Right.
All right.
So number 9 is now in looking like the rest of the document where it doesn't have to be looked at again. So 7 or 10, Judge, do you want me to delete those?
Yes. And then all I need is I want a hard copy piece of paper that I can just slip into these instructions I've got. I don't want a whole new set. We don't have to cut down another tree.
That's why they're on the
I
electronic.
know, but I still print them out because I got to print them out and give them to the jury.
Yes, sir.
All right. Next.
Well, they still say drafted them too, Judge.
I know.
Okay.
Well, you're right. I guess you're going to have to give me
I-
without the draft. So
Yes, sir.
You're right. I'll print them out myself.
and take out number 9, and then the end of that instruction, Judge, we were still waiting to see who we may have to call in rebuttal.
On page 32,
Yes, sir.
yes,
At both of those paragraphs on 32, we have to wait,
okay,
and 33 and 34.
which is defendant
Yes, sir.
testifying or not, that's correct. Also, we needed to talk about page 36, eyewitness identification, and whether or not we were gonna bother with that.
I'm assuming that it says give if, well, I'm not assuming it says this, it does say give if eyewitness identification is a disputed issue and if requested. And I'm assuming that's if requested by the defense, Judge. So the state's gonna defer to Mr. Stroll on that one. I would point out, I
Well-
believe, I'm sorry.
Who said that? You did.
Said
During
what?
jury selection, talk to the hand.
Yes, sir. I got it.
I read that it needs to be in dispute and it has to be requested, not one or the other. I don't see that identification is in dispute. Nobody's questioning who did the shooting.
No, I just think there was probably weighing the evidence. There were some differences in terms of what witnesses said at police.
Well, but there's instructions on weighing the evidence.
No, that's what I'm saying. I don't think, I'm agreeing with the court.
You want this out?
I don't think I would ask for it, Judge. Because
Okay.
it is, I believe it is conjunctive, where it's the disputed issue and if requested, and I don't think we have that disputed issue, that's somebody else's issue.
Do you have any objection to me not giving that instruction, Mr. Stroller?
Not based on the instruction, Judge, no.
Mr. Dunn, how about you? Any objection to me not reading that?
That's it.
Okay. So that's out. And that's it.
Judge, the only other thing too. is-
Well, I say that's it. No, it's not.
You say on 3.6F, you just filed the use of deadly force?
Yeah, hold on, let me get to that.
Yes, sir, Your Honor.
And
Also, obviously, on the verdict
Verdict
forms,
forms.
we've got to fix whatever we're gonna call this attempted manslaughter thing.
Yes, sir.
Okay. Justifiable use of deadly force.
Judge, on that, it talks about other forcible felonies.
Yes.
One, I'd have to put the definitions in, so I'm preparing the jury instruction to add those the way it reads is, for subsection number 2, where I put any attempt to commit aggravated assault with deadly weapon, aggravated battery with deadly weapon. The way it says is you have to add the definitions for the jury, so I have done that. I'll get that instruction to you. That was the only thing I left out in what I had right here. Because preliminarily, I was just putting in other forcible felonies that you have to add by name, Judge. But I do have to include the definition as part of it.
Wow.
Yeah, it's gonna get long.
Gonna be extremely long.
Yes, sir. And I think that goes for the second subsection too as well. I think I have to do it twice from how I read the jury instruction wrong.
Okay. I'll need a half a day to read these. To the jury.
Yes, sir. But Judge, again, we may be a little premature trying to address this because it has to be something other than Mr. Stroll's opening statement on which you
I know,
base.
I understand, I just am anticipating where we're gonna wind up. I think he knows where he's going and what he's gonna do.
Yes, sir.
So, yeah, what you need to, well, let me say this. Here's what I want, because the state's been kind enough to prepare these things and provide copies to myself and Mr. Stroller. That is, he's anticipating he's gonna have aggravated assault and aggravated battery.
With the deadly weapon.
Okay. Actually, that's not a crime. I mean,
Ag battery.
it's just ag assault or ag battery.
Well, Judge, ag battery would require a touching or a striking of his client. an attempt.
That's
to
true.
commit- Well,
I think you
well,
can do an attempt, Judge. If you look at it, attempt to limit is a
No,
forcible
yes, sir.
felony. And it even
Okay.
says, it says, word for word, any attempt to commit a forcible felony. And then-
Well, what he's saying is he would have attempted aggravated battery.
well, and just hear me out, since aggravated assault isn't necessarily lesser included, just hypothetically, if someone were to come into a trial and claim that the person that they shot pointed a gun at them or a weapon, then they would have to show that the person attempted to use that weapon to actually strike them by firing it. I mean, an attempted aggravated battery would require a striking. So an attempt to murder, and it already is in there, it says one's attempt to murder another human being, or an ag assault. I'm just missing the part about the attempted aggravated battery.
I see what you're saying, I tend to agree.
And maybe another.
I think the forcible felony, if there is one, is aggravated assault. Clearly it's not aggravated battery.
But if somebody has a pipe and they're getting out of the car to commit a
Mr.
forcible battery, the word says, any attempt to commit a forcible felony upon him.
I guess it'd be
Again, in number 3 as well, Judge.
It would be an attempted aggravated battery.
Well, we could overanalyze this, I realize, but Judge, that's not a deadly weapon unless it's actually used in a manner consistent with a deadly weapon. So for example, a baseball bat. If somebody actually got out and swung a baseball bat at somebody's head, that would be an attempted aggravated battery because of the way in which it's being used.
Now, I understand, I hear what you're saying. We
Yes,
don't
sir.
know how the evidence is what it's gonna reveal. The evidence may not reveal attempted ag battery. We'll see. Well, we're just gonna have to deal with it on the fly.
Tomorrow, yes, sir. You want us to have our case law ready to go for any possibility?
Yes, please. All right, so that's the first section. How about the second section where it says, well, a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent. I guess that goes in there again.
That's the way the statute the instruction is up.
So the first grade area would turn to black. Then the second grade area would also change. And then we've got to do, however, the use of deadly force is not justifiable if you find. I don't know if that applies. It's an independent forcible felony. I don't know about that.
Which one there are, I apologize.
Where it says, give only if the defendant is charged with an independent forcible felony. See Giles versus State. I haven't seen that case off the top of my head, but I don't know what the independent forcible felony would be. I don't think there is one. The way I see it. I mean, it's not, there's nothing independent about this. To me, that'd be like,
Count five now.
well, then read the next thing. It says the defendant was attempting to committing, or escaping after the commission of the applicable forcible felony.
Hold on, I'm not sure where you are, are you on my instruction I gave you 3.6 F? Because I don't see, I don't have, I think it's different, 'cause I don't have a gray area on mine.
I'm going by what I printed out.
I think I handed you a separate one the other day on a 2-page. The very top says FL, STCR, area instruction 3.6. And I've actually filled in Mr. Dunn's name throughout the instruction.
I think that one's in the back here. Hold on, let me get it. I'll be right back.
All right, she said that the verdict form findings are inconsistent with the jury verdict, so I need to look at that. So pull up the verdict forms on yours. I don't know what's inconsistent.
Okay, I've got yours. Maybe this is easier to look at. Do you have a copy of Mr. Strola's, Mrs. Corey? It's a two-page document.
I had that copy, Judge, but it was missing a lot of portions of the instruction that we needed to address. If there's been the subsequent one turned in, I don't have it.
This was the thing when I handed both parties the other day, Judge. And the only thing that was missing was the definitions.
Right. Do you have a hard copy for her?
Did you take a copy?
I printed one. I did give them one, so I gave them one first before you. I had 3 copies printed out. I have to get on my computer, probably print it out. I went through it, where it said reading all cases, reading all cases. I put in Mr. Dunn's name, and then I put in I assault with a deadly weapon, battery, attempted murder, on subsection number 2 on the form. That's why I was also looking at the rate of research.
Right.
And you had asked us to take out dwelling residence, so I struck that out in red. And the state was objecting to keeping in the Michael Dunn's in an occupied vehicle or a right to be. The state was objected to that and definition of vehicle.
Also, I'm looking at yours, where you've got number 1, another's attempt to murder him. See where it says number 1?
Yes, sir, Your Honor.
And then you drop to number 2, any attempt to commit, you've got ag assault with a deadly weapon, aggravated battery with a deadly weapon, attempted murder or murder. You can take out murder because you got murder up in number 1.
I just didn't know, because it said put in forcible felony, it's here with definitions, because the first one says murder without a definition, so I wasn't sure, Judge. Just because number 2 says that's where you have to add the definitions, if you look up 3.6F.
Right, I understand.
Okay,
I mean, you still have the definitions, but I don't think you need to say the murder part again.
that's why, that's fine, I just put it in there and it's a
And I
caution reminder.
take it out of number 3. And also coming out of number 3 was dwelling and residence.
Just add all definitions, including murder, under that. Or do I add that under 1, though?
I'm sorry?
That's why I'm just a little confused, because my concern is when you look at it, it says another's attempt to murder him, and it doesn't say add a definition. It then says,
I'll put the definition in there.
okay, so we have the definition, we'll do it, I just didn't know,
Yeah, we just don't have to say it twice.
okay, so put it under 2, or put it under 3, or just don't say the word twice.
Right.
Okay, that's right.
Actually, there, I think you probably need to leave it in, because it's not mentioned in number 1.
All right, I just, sure, yes, sir.
And then on the second page, I think it was all fine, except we were taking out dwelling and residence.
Yes, sir, the judge, just to be candid with the court, the state did object to the second paragraph on page 2 as well as the second definition of vehicle. I had state objects next to both of them.
Okay, well, here. Somebody want to use mine? State can look at it. How long you want to look at it before I
Ju-
come back in here and we talk about it some more?
Judge, I've got the entire instruction typed out in mine. I was waiting for him to ask for this, but our concern is.
I want one in
How come-
black.
Yes, sir, I've got it, and I'm changing it to black. Our problem is, I don't know how we can define any of these felonies until after the
I
testimony.
understand that.
Right,
I just want him to see it in the form that he thinks it's gonna wind up in. Then all we have to do is delete from it. If it doesn't turn out like he thinks it's gonna turn out, we're
Okay.
gonna take some stuff out of it. I wanna have one now that'll have everything in it that Mr. Strolla and Mr. Dunn possibly think they're gonna get.
okay,
And then we will just take away from it if it doesn't quite turn out the way Mr. Strolla and Mr. Dunn think it's gonna turn out. And I don't care about the definitions so much. We can plug those in later. I just want the nuts and the bolts of it, so I know where we're going and how this thing's gonna look and read, and we're all happy. With the understanding that we're not finalizing anything until tomorrow. I mean, we're never gonna finalize this until tomorrow. I got that.
okay.
But I'd like to be as close to there as we can possibly get.
And judge, by the end of tomorrow, I'll have the instruction, I just want to be able to say.
Well, I think Ms. Corey is trying to make it work now, and then she can do whatever she does with that, electronically.
I meant the manslaughter instruction, judge.
Oh, yeah. Yeah,
I'll try
that,
to have that solidified by tomorrow as well, judge, just for the sake of the court, so.
yes.
Because you did say we were going to do closings,
Right.
depending on state's rebuttal, things like that, Wednesday. And then we have the final instruction by Wednesday, I will try to have it by tomorrow.
No, we might do closings tomorrow.
Oh, okay. I'll make sure.
I mean, I might be a little bit optimistic there. I don't want to split anybody, but if I look and see, and the state indicated earlier today, they thought they wanted, did I hear correctly, 2.5 hours total?
Yes, Your Honor.
Mr. Strolla, I'll give you the same, I don't know if you're gonna take all of that.
I'll take the same, judge, but I hopefully won't use the same number.
What do you think, you probably got a sense of where you are, what do you think?
I probably say an hour and a half. I mean, these instructions, like.
I know, that's what I was thinking. So, talking 4 hours. I mean, if by some chance we could start at 1 o'clock, then I know there needs to be breaks in there, but I'm gonna have y'all do the closings. We might not finish them until 6 o'clock at night, but we're gonna go.
Now, are you good not to know before I apologize?
Now, if we don't finish the testimony until 2:30 tomorrow, then I'm not gonna do that, because I'm not gonna keep them down here till 7:30 or 8 o'clock at night. We'll come back on Wednesday and start right fresh in the morning. And then, my idea would be, you do your closings, there'll be a lunch in there and all that. I'll give them the instructions, and they'll begin their deliberations. Now, again, I'm not gonna keep them down here all night, but this group seems to like to work. They don't have anywhere else to go. So if they wanna stay down here for a while, that's what we'll do. I mean, we'll stay here till whatever they think is reasonable. I mean, we might have to feed them dinner here. Or maybe what we'll do is just let them work till, I don't know, we can talk about it, 7 o'clock, and they'll be done with it. They'll take them back to the hotel and have their dinner ready for them. Then we'll come back the following day if we have to.
You're not hearing the court correctly before you said we may even have a final jury instruction charge after closings before we hand the instruction. We'll keep these after closings.
Well, generally speaking, my practice is we're finished with the jury instructions before you people get up and give a close.
Okay.
Because you're gonna, a lot of times you all use them in your jury instruction, your closing, you better have it right.
Yes, sir.
So no, the jury instructions are gonna be finalized before you get up to give a close. So I'll give you all a few more minutes to produce these things.
May I ask about something simple that I just would like to know, and I had meant to ask you this, and then our jury instruction expert reminded me of it. She suggested that we don't really need on count 1 of the indictment, murder first degree, this would be page 6. There are 2 ways in which a person may be convicted of first degree murder. One is known as premeditated murder, the other is known as felony murder. That's kind of an introduction when you have both, but I am gonna defer to the court and the defense if you want that deleted so it does not cause confusion. It's the first paragraph on page 6. And Ms. Carbul has suggested we don't really need it, and I agree.
I see what you're saying. Yeah, that, I would suggest that come out, and the way that instruction would begin would be to prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt.
Yes, sir.
You don't need the part above it.
It is standard, but the defense can choose to delete it since we're not asserting a theory of of felony murder in this case.
I would agree, Your Honor. If you can take that sentence out.
Okay.
You said the instruction proves the crime of first degree.
Yes.
That's exactly.
All right, is that satisfactory to you too, Mr. Dunn?
Yes, sir.
Okay.
All right, that's out then, Judge.
All right, so you're gonna fix these things now and email, whatever you do, another copy.
Put it in the
Another set.
electronic file, yes, sir.
So I'll
These are
have
fixed,
them.
and I'm gonna look at the verdict forms again. Apparently, I may need to tweak the verdict forms a little bit, but I'm going to leave everything about manslaughter, and it's really only attempted manslaughter. Regular manslaughter apparently is fine. I'm gonna leave all of that like it is until you tell me otherwise. And then you want us to sit and go over justifiable use of deadly force?
Right.
Yes, sir.
And then I'll come back here and you tell me, 20 minutes?
I'll just have to run back to my conference and get on my computer.
Okay. I'll come back in 30 minutes. Whatever
Okay.
y'all want.
Well, can I ask you a question?
Sure.
What murder are you gonna define? If he says another's attempt to murdering, which murder instruction would you be defining? That's what's difficult about these instructions. So, are you actually gonna read an instruction that says Jordan Davis premeditatedly attempted to kill Michael Dunn? It's just very,
I agree with you
Confusing.
100%.
Yes, sir.
In my way of looking at it, it's, I don't understand it.
yes, sir. I tell you what,
if-
Judge,
If you were trying to confuse the jury, it's gonna happen. My mind would be numb after all of that.
And it says that you have to add the definition to it.
I've never had it happen before. I don't know. You tell me.
well, why don't we just, if you'll give us about 30 minutes,
Yeah, let me
Judge,
give you
we'll
30
work,
minutes.
and we'll do the best we can on paragraph by paragraph.
Okay.
Okay, thank you,
Let's do that.
Judge.
Yep.
All right.